Okay, welcome back. And just to recap, we're in the third session of a little group of discussions in which first we established the origins of this new mental defense, the expansion of psychiatry's role in the criminal courts, the diminished capacity defense, with Dr. Bernard Diamond being the star from psychiatry, leading the field and convincing judges to let psychiatrists come in, even though there was no insanity defense. Then we went into the facts behind the trial of Dan White, the San Francisco former policeman and fireman and veteran, military veteran, who executed Mayor George Moscone and Supervisor Harvey Milk, now was on trial for murder. But we didn't yet get into the trial, and I want to do that this time. You know, that was the first and only time I ever went to a prosecutor and urged him to hire me in a case. That's not something I would do normally. But the Dan White trial was a subject of enormous controversy and turmoil in the San Francisco area. The gay community was in a complete outrage because Harvey Milk was a hero to them, justifiably so, out there defending their position in the community, representing their interests, and an inspiration, in my view, to the nation. I mean, we in the Bay Area, we're proud of the fact that San Francisco welcomes the gay community, and I think it's been vindicated by our society's movement on the issue of on these issues of different populations in our society and their right to be equality. So I went to the prosecutor handling the case. Thomas Norman was his name, because just by following the news, I was familiar with the fact that the defense, this was going to be psychiatry with bells and whistles on. The defense attorney, Douglas Schmidt, was well known in the defense community as a skillful lawyer who would be able to pull out all the stops with psychiatry. And they were now armed with language that had been created through the work of Dr. Diamond and Charles Gary that you heard about in the last sessions. The law would now include words like meaningful and mature deliberation, an awareness of an obligation to society. In other words, this language which would just open the door wide open to what were in essence like almost philosophical concepts. Who knows whether somebody, excuse me, had meaningful and mature deliberation? What is that? Do I know how many times I'm using meaningful and mature deliberation? I certainly don't. I hope you don't either. It's just, you know, it's very fuzzy stuff. So now we had a trial in which a very clever lawyer was going to be able to pull out the stops with his psychiatrists and psychologists. And I had learned from asking around that prosecuting attorney Thomas Norman only planned on calling one witness as rebuttal to the defense's 5 mental health professionals. Now, I knew who that psychiatrist was, and I knew that he would also be examining Dan White. So you'd have 5 mental health professionals who had examined Dan White and were going to testify for the defense, and one psychiatrist who would use the same methodology, the same so-called clinical examination. In other words, he would talk to him, and that would be called a clinical examination. Some psychological tests, probably pencil and paper tests. You know, you've heard of the Rorschach or inkblot test or some other, can't get into it in this session, but really kind of a joke, the idea that these things could help. 5 against 1. I could smell it. I could feel that there was a real danger that he would not be found guilty of murder, even though the prosecutor told me, no, it's a slam dunk. What Dan White did is so obviously murder. He obviously intended to kill him. And Dan White had no history of being a mental patient. Nobody ever thought he was out of his mind. I tried to tell Thomas Norman, look, 5 witnesses against one who's doing the same things. You know what I do? I will not talk about Dan White's mind. What I will talk about is what I do in these cases. I will teach the jury why the methods used by these 5 psychiatrists of defense aren't worth anything. I will explain what the methods are. And they will understand that they don't help. And since the law gives the jury the power to decide what weight to give this testimony, they will ignore it and convict Dan White of murder. But he didn't agree with me. He just didn't think he needed it. So I did not get a chance to explain that to the jury. So these 5 doctors did, and they were, at least as far as the way the media reported it, the psychiatrist who got the most bad rap, and deservedly so, was Dr. Martin Blinder. Now, Dr. Martin Blinder was, once again, not just a psychiatrist that you could just go to the phone book and find his name. He had a very well-established reputation, at least in the community of defense attorneys. I had already been involved in cases opposing him by doing it my way, not examining the accused, but examining what Blinder was doing and then ascribing it to the jury. But Dr. Blinder also was on the faculty of the law school, one of the law schools of the University of California, the Hastings Law School in San Francisco. Had testified in many, many trials. Well, it was Dr. Blinder who then eventually testified that if it hadn't have been for the depression that Dan White was suffering from and the resulting binges on Coca-Colas and Twinkies, remember those sweet little things, I'm sure they're still around, that you can snack on? It was too much sugar that caused Dan White to snap, and that a man like Dan White would not have committed those 2 brutal murders. 4 more mental health professionals then came along and talked about similar things, that he snapped, that he really wasn't aware of what he was doing, that when he fired those shots, he really wasn't capable of intending to kill. And in the end, the jury decided that he was not guilty of murder. He was only guilty of manslaughter. And that could have only happened not just from the psychiatric testimony, but from the way the trial unfolded. That is, the trial, in essence, became like a clinical case conference in a mental health clinic. So what happened in the Dan White trial could only have happened once psychiatry had successfully established expanded definitions of mental state that was relevant to courts at the time of committing a crime. An expansion for psychiatry's role, which is what they wanted to happen. Dan White was found not guilty of murder, even though we all know that he was guilty of murder because of his behavior. His behavior demonstrated that he had a purpose to kill these 2 men. Because after shooting them twice, each one, he went up to them and pointed his gun against their head from inches away and fired twice more. Such behavior could only be the result of somebody who is intending to kill, which is the definition of murder. So it was not only the testimony of the 5 doctors, but the law that was in place, which allows the definitions to have been changed to, did you have meaningful and mature deliberation? Did you think about what you did in a certain way? And the psychiatrist would examine you to determine whether you did or not. So what I want to do is I want to read to you a little more so you don't take my word for it. I'm going to read from The Reign of Error, a book that I published in 1984, because obviously I haven't memorized their testimony. I already told you about Dr. Martin Blinder saying that the Cokes and the Twinkies, the sugar in his blood from his binging as a result of being depressed, explain why he would do such an uncharacteristic thing. After all, he'd never before executed a mayor or a supervisor. But there was another psychiatrist, George Solomon, who said, I don't think that he would permit himself, that he was capable of permitting himself to plan something so awful, that he was, quote, in a dissociated state of mind, that he blocked out of his mind his awareness of his duty to uphold the right. How a psychiatrist would determine somebody had blocked out of their mind something like that, don't ask me. He further went on to say that, in his opinion, the gun was not for the purpose of killing somebody, but was just a security blanket, that Dan White felt he needed this gun for his own security, and that he was kind of on automatic pilot when he actually did the killings. Then there was a psychologist by the name of Richard Delman who said that the reason Dan White didn't go through the front door of City Hall and convinced a construction worker to let him go through a window on the side of the building was not to escape detection and go ahead and kill these two people, but he didn't want to embarrass the officer who was manning the metal detector. And then finally, a very prominent psychiatrist from Stanford University, Dr. Donald Lundy, said that as a result of his examination, he didn't believe that Dan White was able to consciously fabricate, that when he actually did the shooting of these two men, that White was only vaguely, quoting Dr. Lundy, that he was vaguely only aware of the mayor and of the mayor falling and of the gun going off again. That he really didn't understand what he was doing, that if I pull my finger, pull the trigger, this will kill somebody. No, he was not able to do that. So the jury heard all this testimony. One psychiatrist who didn't agree, but his disagreement, the prosecution psychiatrist, this is crucial, was based on doing the same kind of so-called examinations as the 5 doctors who were testifying for the defense. So in essence, the trial became kind of like a clinical case conference in which we sit around and we decide, why is somebody behaving the way they behave? That was possible because the attorney was able to take advantage of laws which raised those kind of psychiatric questions. Why would somebody do what they did? And were they thinking in a certain way, feeling in a certain way? All of things which do not belong in a court of law. The legal tests that we had before Dr. Diamond and Charles Gary invented the diminished capacity defense were already in place to inquire about whether you had basic intention or not. If your intention was to kill, it's murder. If it was not to kill, but nonetheless you did kill, it's manslaughter. Simple, basic, common sense distinctions which do look into the mental state of the accused, but do not ask psychiatrists for these fine distinctions. That's where the corruption of the system in mental states and the criminal law started. It was psychiatry's doing, and it's still with us. We have made some reforms. I'm happy to say I had something to do with that, but it was a broad reform to reduce it, but it's still there. We still allow psychiatrists to go into court based on these phony examinations, corrupt the courts, spend our money, waste our energy, and hinder us from making decisions based on justice and common sense.